Welcome to today's program titled Mastering CTA Compliance. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you received recently. Copies of the program's recording and materials will be distributed to all attendees in the day ahead. At this time, I would like to turn it over to our first speaker. Stan, you may begin.
Thank you. Hi and welcome to everybody. I'm Stan Block. I'm a partner in CIFAR's New York office. I'm a corporate partner. My practice is principally M&A and transactions related to M&A, such as operating agreements, partnership agreements, and the like. We're looking forward to giving you some insight on this complex act. And I'm going to turn you over to Ali Audi to tell you about herself.
Hi everyone, my name is Ali Audi. I'm a managing associate in our Chicago office. My practice also revolves around mergers and acquisitions and general corporate governance. So I'll turn it over to Moshe.
Hi everyone, I'm Moshe. I am a corporate associate here in New York. I am, like Ali and Stan, I primarily work in the mergers and acquisitions space. I also do a lot of joint venture work and corporate governance work. Back to you, Stan.
All right, so let's pick this up. What are we going to cover today? What is the CTA? So the CTA is the Corporate Transparency Act. You'll hear it referred to today as the CTA or the Act, or maybe the Corporate Transparency Act. You can see on the screen highlighted the purpose for which the Act was adopted. I think I said it was enacted in 2020. It became effective January 1, 2024. And then simply put, the act was enacted to seek disclosure of entity ownership for the purpose of preventing money laundering and other criminal activities. Filings under the Act are made through a subdivision of the Department of the Treasury known as the Financial Crimes Enforcement Network, shorthanded FinCEN. Next slide, please. I want to go back and cover what we're going to talk about today. So we're going to talk about what the CTA is. We're going to talk about, you're going to hear the term reporting companies and what is a reporting company and what is not a reporting company. We'll also be talking about what are the required filings and when are they required. You'll hear the terms beneficial owners and company applicants, which are key terms used in the Act and relate to the information that is going to be filed. And then lastly, we'll talk about resources that are available for helping you along with regard to compliance with the Act. Next slide. The Act is, the government takes the Act fairly seriously. There are significant penalties for willfully, and that's the magic term, failing to report or willfully providing false information or fraudulent information. The penalties are, they're civil penalties of, they started out at $500 per day. They're subject to adjustment for inflation, and that $500 per day penalty is now $591 per day for failures. There's also criminal penalties which are applicable. and the criminal penalties are up to a maximum of $10,000 and 2 years in jail. So imprisonment is possible for willful failures. And we keep hearing questions from clients, do I really have to do this? And the answer is, you really should do it. And if you don't do it, you've got this exposure that we've just laid out. Next slide, please. So who is required to report? And to be clear, there's some confusion in the general population on this. It's we're going to refer to reporting companies. So the reporting is done by the entity, not by what you'll hear beneficial owners or applicants. And every entity that is formed by a filing with the Secretary of State or a similar office in the U.S. is required to file. So this would include corporations, limited liability companies, limited partnerships, statutory trusts, and such entities, sole proprietorships, for which frequently there are DBAs filed, but are not formed by filing with the Secretary of State. Similarly, general partnerships are generally not reporting companies, and those are not entities required to file, therefore. Next slide. We're going to talk in a minute about exemptions, because we've just said every company that is formed that has been formed or is going forward is formed by the filing with the Secretary of State is required to file a report unless it's exempt. And we'll talk about exemptions in a moment. I wanted to mention that there are a number of court challenges to this act. There was a decision in March of 2024 which held that the act was unconstitutional. That decision, however, is limited to only the plaintiffs in that case and not to anybody else. There are other pending actions which are seeking also declarations of unconstitutionality. I think it's unlikely that there'll be any definitive decisions on this before the end of the year. In addition, there's legislation pending currently or relating to the act. Some of that legislation is to try to take care of the deficiencies that were found in the case that determined it was unconstitutional. Some of that legislation, there's a pending bill in the House, which is called the Big Brother Overreach Act, which is looking to negate the act in its entirety. It's unlikely that any of this legislation will move before the end of the year. And so as we move forward, I think the assumption has to be that this act is going to be in effect. And as you go through planning, preparation, and run up into filing deadlines, you should be prepared to file and satisfy the requirements of the act. As I mentioned, there are a number of exemptions. Actually, there are a total of 23 exemptions. Most of those exemptions relate to companies or entities that are regulated already, highly regulated by the government. So, for example, public companies, insurance companies, banks. There's a list, a large list of companies, and you can see that at the bottom of this slide, are exempt. in addition, now let me say they're exempt, but if they lose their exemption for any reason and cease to be exempt, then there will be a reporting requirement to be made by them. And that is that they will have to report within 30 days after the exemption is lost. So for anybody in the audience who is representing an exempt company, keep in mind that if the exemption goes away, the reporting requirement will be applicable. So with that, I want to turn this over to Moshe, who is going to pick up and discuss two of the more important exemptions. It may be more than two, but at least two of the more important exemptions.
Thank you, Stan. Yeah, so one of the exemptions that we're seeing clients use, or at least try to use a lot, is the large operating company exemption. The large operating company exemption requires the reporting company to have 20 full-time employees, in the U.S., an operating presence at a physical office in the U.S. that the entity owns or leases, and have filed federal income tax or information returns in the U.S. for the previous year, demonstrating more than $5 million in gross receipts or sales. So you have a number of, we've seen a number of structures where clients have thought that they would be eligible to use the large operating company exemption, but they didn't meet all the prongs. So for example, if a client has a parent entity and the parent entity has a subsidiary and the subsidiary has 20 full-time employees. The subsidiary has an operating presence at a physical office in the U.S., and the subsidiary has $5 million of gross receipts. Well, if the subsidiary is filing its own tax return, or it's filing consolidated tax return with the parent entity, then the subsidiary entity will be exempt because it meets all the prongs. The parent entity, however, may not be exempt because it doesn't have 20 full-time employees. So you can't consolidate your employees across a consolidated group of companies. Each company needs to have the 20 full-time employees. On the other hand, the $5 million of gross receipts can be consolidated across a consolidated group of entities that are filing consolidated tax report. So if you have a company that has 20 full-time employees, but it doesn't have $5 million of gross receipts on its own, but with its consolidated group it does, then that entity, that company may qualify for this exemption. One other scenario that we're seeing is the scenario where a single member LLC, which is a disregarded entity, meets all of these qualifications, or meets all of these prongs, but it doesn't file a tax return because its parent company is the one filing the tax return, because the single member LLC is a disregarded entity. So in that case, it would seem the single member LLC, which is a disregarded entity, cannot meet this test because it does not have $5 million of gross receipts reported on its tax return because it is not filing a tax return. Another issue that this raises is if you have an entity that was formed this year, for example, it never filed a tax return. So even if it's expected to have $5 million of gross receipts, or it does have $5 million of gross receipts this year, since it didn't file a tax return in the previous year, it cannot meet the exemption. Another well-used exemption is for tax-exempt entities. So tax-exempt entities are generally going to be exempt from the reporting requirements, as are subsidiaries of, or wholly owned subsidiaries of, some of those tax-exempt entities. They'll be exempt from the reporting requirements.
Moshe, can I interrupt you a minute?
Sure.
Subsidiaries of exempt entities. I think you
I'm sorry, yes. So the subsidiaries of tax-exempt entities, but also, I should have clarified, subsidiaries of all exempt entities or most exempt entities are going to qualify for the subsidiary exemption. So if you have a parent company, the parent company is exempt, perhaps it's a public company that is exempt. It has a number of wholly owned subsidiaries. Those wholly owned subsidiaries are going to be exempt. Even if they don't themselves qualify for an exemption, they're exempt because they are subsidiaries of an exempt entity. If you have a public company that has a joint venture, well, in that case, the public company may be exempt because it's a public company, but its subsidiary joint venture is not necessarily going to be exempt because it's not wholly owned by the public company exempt entity. If the joint venture partner is another exempt entity, in that case, the joint venture may be exempt because now it is entirely owned by exempt entities, even though it's not fully owned by one exempt entity. All of its ownership interests are owned by exempt entities. Then another exemption that we're seeing people try to use, but it's really narrow, is the inactive entity exemption. Can we have the next slide, please? The inactive entity exemption is very, like I said, it's very narrow. It only applies to entities that were formed prior to January 1, 2022. I'm sorry, yes, they're in existence prior to January 1, 2022. 2020 did not engage in business and do not have foreign persons as owners, have not experienced a change of ownership in the past 12 months, and have not received more than $1,000 in funds in the past 12 months, and do not otherwise hold any assets. So as you can see, it's very limited. It doesn't pick up a lot of entities that may have been dissolved in the, for example, you formed an entity in January of 2021, you dissolved it sometime in 2021, that would not be picked up by the inactive entity exemption. However, FinCEN has recently clarified in the FAQs that although it doesn't qualify for the inactive entity exemption, if an entity ceased to exist as a legal entity before January 2024, it was never a reporting company because although it's not an exempt entity, it just doesn't exist to be to need to file a report. But FinCEN did say that in order for an entity to be considered dissolved, it has to have entirely completed the process of formally and irrevocably dissolving. So what FinCEN has done there is that it depends on the state. So if it's, if in a certain state, an entity files a certificate of dissolution or a certificate of withdrawal, but it's not completely dissolved, then it's not going to be, it's still going to have to file a report. FinCEN said that in a situation where you have a dissolved entity that needs to file a report, you would file for the beneficial owners that were the beneficial owners immediately prior to the entity dissolving. An entity that existed in 2024 or later, even if it ceased to exist before its initial report date, so we'll discuss the initial report dates in a moment, but for example, if you have an entity that was formed in January of 2024 and it was dissolved 2 weeks later, still in January of 2024, it will still need to file a report because it was a reporting company after January of 2024. Next page, please. Next slide. All right, so now we've discussed what is a reporting company and what are the exemptions from the reporting company definition. once you've established that an entity is a reporting company and is not exempt, you now need to file a report. So when does that report need to be filed? If the entity was formed prior to January 1, 2024, so it was existing as of December 31, 2023, then the entity has until the end of 2024 to file. It has until January 1, 2025. If the entity was formed after January 21, 24, but before January 1, 2025, then it has until, it has 90 days from the date it was formed to, and in the case of a foreign entity that was registered to do business in the U.S., from the date it was registered to do business, has 90 days to file. For an entity that was formed after, on or after January 1, 2025, it will have 30 days to file. So initially, FinCEN said every entity that's formed after January 1, 2024 has 30 days, but because this is the first year, they gave companies extra 60 days to file. What information?
Moshe, let me jump in for a second. In my presentation, I said reporting companies are entities that were formed by the filing with the Secretary of State or similar body. Moshe's just referred to foreign entities, and I should have added that an entity which is formed in a foreign jurisdiction and then qualifies to do business by the filing with the Secretary of State in this country will also be a filing entity, a reporting entity, I mean.
Yes, and like I said, the timeline will be 90 days or 30 days, depending on when it was formed, or when it was qualified to do business in the U.S. The filing is, well, we'll discuss in a moment what information needs to be filed. For all entities, you need to file information about the beneficial ownership. So we'll discuss what that means momentarily. For entities that were formed after January 1 or on or after January 1, 2024, you also need to file information about the company applicants. And we'll discuss what that means, but that generally means the people, the lawyers or paralegals who filed the information about who formed the company or registered it to do business. The information that needs to be reported is reported through FinCEN's online portal. We have a link to it later on in the slides. It's a relatively simple report, although we'll get into what information needs to be included on that report. And if there's any information that needs to be corrected, if information was wrong or information changed and needs to be updated, you need to file that updated report or corrected report within 30 days after you discover that change or the inaccuracy. So you have 30 days from when any information changes in order to update the report. When you file an updated report, you have to file all the information again. So if you have, for example, 10 beneficial owners, and one of them changes their residential address, you'll have to file an updated report with all 10 beneficial owners' information included. The deadline for existing entities, this is a little bit of a quirk, but if you have an existing entity that loses its exempt status in 2024, so FinCEN has taken the position that that entity has the longer of until the end of 2024 or 30 days. So if an entity loses its exempt, generally if an entity, Stan mentioned this before, but generally if an entity loses its exempt status, it has 30 days to file a report. If the entity loses its exempt status in 2024, so it gets the benefit of 30 days or the longer of the end of the year. So it depends when it loses its exempt status in 2024. Next slide, please. what information is required to be disclosed? So the CTA requires the company to disclose information about the company itself, its beneficial owners, which again, we'll get into what a beneficial owner is. And like we said, if it's an entity that was formed or qualified to do business in the US after January 1, 2024, it will also need to include information about its company applicants. For the company, the entity needs to file its full legal name, any trade names or DBAs. This is something to keep in mind for updated reports. If you file a new DBA, you obtain a new DBA for your company, you need to make an updated report. If there's a current address, the entity needs to file its current address in the US, its principal place of business. If the principal place of business is outside the US, its primary location in the US. It needs to report its state or foreign jurisdiction of formation, and it needs to include its taxpayer identification number, which can be an EIN number. In cases where you have a disregarded entity that does not have an EIN number, so first of all, yes, you do need to file a report for a disregarded entity, but FinCEN has clarified that you could use its parent company, if it has a parent company's EIN, for that report. If it doesn't have a parent company, it's owned by a sole proprietor, then you can use the sole proprietor's social. For beneficial owners, you need to disclose the legal name of the beneficial owner, their date of birth, their residential address, and the unique identifying number and jurisdiction from a state or locally issued or federal issued identification, such as a passport or a driver's license, as well as a copy of the passport or driver's license from where the identification number came from. Next slide, please. There's an option to get a FinCEN ID. A FinCEN ID is an ID that's issued by FinCEN to an individual. That individual can use it if that individual is the beneficial owner or a company applicant. And instead of reporting or submitting all the information about that individual to the company and having the company report it, the individual can go online, get a FinCEN identifier, submit their own information to FinCEN, and just give their ID number, their FinCEN ID number, to the company to report. What this does for the company is it takes some of the onus off the company, because now the company no longer has to file updated information if that beneficial owner changes their address or the like. But the beneficial owner will now have the onus to do that, and if they change their residential address or any other information that they submitted to FinCEN, they'll have to go and update their FinCEN ID. This can, it can be really helpful for companies. It makes the process a bit easier. But companies do have to keep in mind that while getting a FinCEN ID from a beneficial owner will make it easier, it doesn't take away the entire onus of updates, because, for example, if there's changes to who the beneficial owners are, the company still needs to file an updated report. One of the other benefits of a FinCEN ID is that the company doesn't need to hold all of the information regarding that individual, because that individual is giving the information. So it takes some of the data security issues away from the company. We've been advising clients that they should try to get their beneficial owners to obtain FinCEN identification numbers, because it does make the process easier for the reporting company. Next slide, please. So who are beneficial owners? Beneficial owners generally fall into two buckets. They are people who own or control 25% or more of the ownership interest of the entity. And this can include convertible notes, warrants, options, and the like, whether or not they're exercised. So it can sometimes be a little bit of a process to determine who owns or controls 25% more of the ownership interest of the entity. But this part is generally relatively simple to determine who the beneficial owners are that can own 25%. And don't forget, the beneficial owners looks back to who are the natural persons. So we're not looking at entities that own 25% more. We're looking through the entities to the natural persons who own the ownership interest. So if you have a company, it has a 25% member that's an entity, and that 25% member is owned by two individuals who 50-50. Well, neither of those individuals own 25% of the reporting company directly or indirectly. Each one owns 12.5%, so they're not going to be beneficial owners through this prong. The other prong is, or the other test to determine if somebody is a beneficial owner is if a person exercises substantial control. Substantial control can be negative control over the entity, but substantial control is generally can be broken down into 4 different buckets. It's people who are directors or senior officers of the company, so that includes the CEO, president, and the like. And anybody who is, it's not necessarily, it's not important what the person's title is, it's important what control they have. So if they have the control that a CEO or president or general counsel would have, that would all be senior officers. It's a person who appoints or removes or has the power to appoint or remove senior officers or a majority of the directors. So that's the second group of substantial control people. It's anybody who makes, approves, or influences major decisions of the entity. So you might have a partner, a JV partner, who has major decision rights over a company, and that can make that JV partner a substantial control person, even if they don't otherwise own 25% or more of the ownership interest of the entity. And then there's a catch-all for anybody who otherwise has substantial control. So as you can see, the substantial control definition is extremely broad, and it does raise questions about where to draw the line at times, because a lot of times there's judgment calls to be made about whether somebody has substantial control or not. Next slide, please. For entities formed from January 1, 2024 and later, we've said that they need to report information about their company applicants. Who are company applicants? We'll get to that on the next slide, but a company applicant is required to report the same information that a beneficial owner would have to report, except a company applicant a company applicant's information does not need to be updated. So if the company applicant changed their address, the company does not need to file an updated report to notify FinCEN of that. Additionally, company applicants can use their business address instead of their residential address. FinCEN identifiers are available for company applicants, and we're seeing them used a lot by company applicants. So, for example, we'll get to on the next slide again what company applicants are. But if you have a service company that forms an entity for you, typically they'll provide you with the FinCEN identifier of the person at the service company that actually made the report or filed the certificate of formation or other governing document of the reporting company. One thing to keep in mind is that when somebody obtains a FinCEN identifier, there's an option to either provide a business address or a residential address. And it would seem that the option to provide the business address should only be used if you are obtaining the FinCEN identifier in order to report as a company applicant. But if you're also going to use your FinCEN identifier to report as a beneficial owner of a company, it would seem that you should use the residential address option when obtaining the FinCEN identifier. Next slide, please. So who are company applicants? Well, let's start with this. FinCEN said that there must be at least one, and there can be up to 2 company applicants per company. Well, there can be more, but there needs to be 1 and up to 2 that are reported. The first one is going to be the individual who directly files the document that creates or registers the company. And there will be times when that will be the only company applicant, the individual who actually files the certificate of formation or incorporation with the company. But if there's more than one person involved in the filing, so there's a lawyer who submits the certificate of information to the service company, or a client does that directly, or if there's a lawyer overseeing a paralegal, there's going to be more than one person involved in the filing, then the individual primarily responsible for directing or controlling the filing will also need to be reported. Many times that will be the partner at the law firm or another employee at the law firm. But in some cases, if the client goes directly to the service provider, the client may be the one that is primarily responsible for directing or controlling the filing. Next slide, please. And with this, Ali, take it away.
Thanks. So we've covered a lot of information so far, and we thought it'd be helpful to share a lot of the helpful resources that FinCEN as well as CIFARS has. The first is you can file the BOI report with FinCEN online. That link should work to be able to take you directly to where you need to file it. And then FinCEN has also issued a video demo that goes through the steps on how to file the BOI report, as well as they've issued filing instructions. And then for the FinCEN identifier numbers, there is a link to the application, and something that we've really stressed to our clients is that it's a very easy application process. Takes a few minutes to get everything in there and then get the FinCEN identifier. There's also the FinCEN issued FAQs. This is a really great resource. It's a very comprehensive Q&A on different compliance guides with step-by-step instructions, and it goes through the exemptions in pretty great detail. Same for the small entity compliance guide. It provides a great resource for detailed guidance on the CTA and all the relevant information that you need to gather for your filings. And then last, there is the CIFARS resources, which we've put together, which has different resources and webinars that you can reference. Next slide, please. Okay, so now that we all have a better understanding of the different filing requirements that the CTA requires, we wanted to just bring forward and discuss some actions that you can take to best position yourself for gathering the required information, as well as maintaining compliance with the CTA. If you want to go to the next slide, please. So for preliminary matters, and to the extent that you haven't already done this, you want to identify who in your organization will be responsible for monitoring CTA regulations and notifying the company of any changes. It's especially important to be aware of any changes that FinCEN might come out with, and it's helpful to designate people within your corporation to be in charge of monitoring that. And then something that many attorneys at CIFARS have done is even sign up for alerts with FinCEN. Provides you an update if anything does come out that you can relay back to your company. The next preliminary action is to adopt company policies regarding CTA compliance. So this is really just considering your internal compliance policies such as who's going to be responsible for gathering all of the CTA information and who's going to make these required filings, and possibly if everyone needs to be required to get a FinCEN ID, to also be considered as well. Also, you can consider if you want to develop a CTA-related training as needed to bring your people up to speed on what needs to be done, what needs to be filed, and what they should be looking out for. Something that I've seen more in the M&A space is an M&A transaction happens, but the person in charge of the actual filing may not be putting all of that together yet. So just making sure that you have the internal policies in place so that everyone that is responsible for the compliance is aware of what's going on with the organization. The next step to do is just to review your company's org chart, the ownership and other records, and make sure that they're up to date. You may also want to just review and determine if there's any DBAs or trade names out there that you need to review. Last, you want to determine if any exemptions apply, and then you want to memorialize these exemptions. So really this is going on a case-by-case basis, especially if you have many different entities within your org structure. You want to go through and see if the exemptions apply, and if you do determine that an exemption applies, we recommend to our clients to, prepare some memorandum to file, put your analysis together on why it may not apply, and just save it in your own file where it can be easily accessible in case you need to reference it later on. Next slide, please. And then we covered a lot of these already, but something to just keep in mind is that with all of the collecting and reporting of information, that it can be pretty time consuming. So it's helpful to get the information that you can early on. So that's collecting your information on your reporting company, identifying any beneficial owners, as well as collecting FinCEN identifier numbers if they have any, or even recommending to your people to go out and get the FinCEN identifier numbers as quickly as possible, as well as identifying your company applicants, and getting all the beneficial owner information. So next slide, please. So once you've collected all the information, and as we've kind of discussed, that there's some very strict deadlines to keep in mind with the BOI filings. So if you're a non-exempt reporting company and you existed before 2024, the initial reporting company filing is due by the end of 2024, which is coming up quicker than I think a lot of people like to think of. And then if the company is established on or after January 1st of 2024, you have 90 days from formation to make that initial report. And then once you get into 2025, you will have 30 days to make the initial report. So given there's so many different timelines, but now that we're in 2024, something that we often do with our clients when forming a new company for them, or even if we know a company that has already been in existence, we're putting calendar reminders. We're trying to remind them as much as possible, this date is coming up, be aware of it, start getting your filings together, start getting your information together. So that's a way that we recommend to our clients to keep track of these ever-changing dates. And then once you've determined when your BOI report is due, you want to make that filing online. And then once you make your submission, you should also receive some type of acknowledgement of the submission, acknowledging receipt, and then you should be able to download a transcript of your actual report. And then we recommend that you retain all of these records for yourself and something that you can reference in subsequent filings. So the next slide, please. So these are some post-filing considerations for you to consider, such as implementing a compliance process to monitor and report any changes of the BOI reports, as we've kind of touched on. Making the updates in a timely manner is very important. So you really want to have some sort of policy in place or someone in charge of monitoring all of that. And then you also would want to file a corrector report if the reporting company ever discovers an inaccuracy. So you have 30 days after discovery of an inaccuracy to file a corrector report. And then if an exemption applies, you want to continue to monitor to make sure that exception continues to apply. This is something that I've seen come up in M&A transactions, and just making sure you're always on top of these exemptions as things can change. And that if that exemption stops applying, then you have 30 calendar days from when that exemption no longer applies to actually file the BOI report. And then something that we touched on was the special rule for existing companies that lose their exemption in 2024, that you have 30 days or later until the end of the year to file that report. So if you realize on December 15th that you've lost the exemption, you have 30 days from then instead of 16 days to squeeze it in. So, and then once the reporting company becomes exempt, you have to update that BOI report within 30 calendar days that it meets the exemption criteria. Next slide, please. Okay, so on this slide, we've just identified a couple best practices to consider and different policies and procedures for CTA compliance. With respect to data security, we've talked about reporting companies maintaining a lot of different personal identifiable information, like someone's passport or someone's driver's license, which can bring up compliance issues for the companies. So you might need to revise different internal processes and policies to make sure that that information isn't compromised and it's being handled correctly. And something else to consider is if you do have foreign individuals, think about what foreign policies might apply for having that foreign individual's personal information as well. And then this is, again, just a good reminder and something that we always tell our clients that citizen IDs come very important for. It helps reduce the risk, not completely remove it, but helps reduce the risk of maintaining so much personal information. And then general company practices. So we're seeing corporate governance and other documents relevant to the CTA be amended or revised to include different provisions that include CTA compliance. For example, we've seen shareholder agreements or LLC agreements amended to include some type of affirmative covenant or action that the members will be compliant and give information and give all the information necessary for the filings. And it's something to consider at the outset of when you're drafting these agreements too. Do you want to include an affirmative covenant requiring those people to provide the information? Take a look at your convertible notes. They may not have equity now, but if they do you want to obligate them to provide the information now or have a commitment to provide you the information in the future? And then director and officer agreements, we've seen that to the extent that there's any liability with respect to CTA reporting, if you want to consider including indemnification in there. And then the last item is to consider whether dissolving inactive entities would be beneficial to minimize your reporting requirements. Just something to keep in mind, go through your org chart. If there's a company that you can dissolve, it might be best to minimize all of the reporting. So on the next slide, we will go to our CLE code. So we have the QR code, but the verification code is SS as in Cypher Shaw 6310. It's SS 6310. And then the evaluation form and CLE attendance can also be made available following this webinar. With that, I will turn it over for Q&A.
Before we jump into Q&A, I'd like to put a ribbon around a couple of things we've talked about. First, we've referred you to the Small Business Compliance Guide that's published by FinCEN. This is a very, very helpful and very readable guide considering some of the complexities here. We alluded to exemptions. It lays out the exemptions perfectly. It provides a checklist for exemption requirements. and I'd strongly recommend for anybody who's looking to understand better how this reporting works. The guide is a great document to look at. It's available on the FinCEN site. I think there's also a link to the guide in the slides that you'll be able to access, but it's very, very usable. That's number one. Number two, we've talked about the FinCEN identifier. From the company point of view, it's very helpful because the company then will not be required to update information concerning its beneficial owners. But it does shift the onus as between the government and the person who holds the FinCEN identifier. It shifts the onus on the FinCEN identifier holder to update his or her information with FinCEN as that information changes. Allie was referring to a number of company documents that you may want to modify to require your beneficial owners to update their information with the company if you don't have FinCEN identifiers from them. But on the other hand, I want to be clear that one way or the other, the beneficial owners are going to have duties to update their information. By having them get FinCEN identifiers, that duty will be between them and the government. And if they don't update it, they'll be subject to fines that we described before. So it's something very helpful to keep in mind. FinCEN also, if you go to their site, you can get onto their mailing list. They're periodically updating their FAQs, and sometimes the information that's being updated is very helpful. And so if you're responsible for staying up to date with what's going on with FinCEN and these filings, getting onto their mailing list can be a very good tool for you. And with that, I'm ready to jump into Q&As.
Great. We've got a number of questions here, so let's try to cover as much as we can. We received a few questions about which individuals can be liable if a company fails to report information. Stan, is that one you want to cover?
Yeah, I can take that. In general, FinCEN provides that senior officers of the company are responsible for the filing or the failure to file and are responsible for updating and the like. Senior officers are listed by FinCEN who they consider senior officers, but it would be presidents, general counsel, vice presidents. Therein lies the responsibility. So it's important to pay attention to getting these filings done, period.
Yeah, and I think the other bucket of people who can be liable is if there's a company applicant or a beneficial owner who fails to provide information to the company that the company needs to report, so then that person, caused the company to fail to report or to properly report, so that person can be liable as well. But as Stan said, generally the onus is on the company and the company's senior officers to make that report and to update the report. We also received a few questions about FinCEN identifiers. We had a note in the slides, and I actually skipped over it, but if a beneficial owner or a company applicant obtains a FinCEN identifier, then that person, as of now at least, that person does have a obligation to update it for a lifetime, even if that person, is no longer a beneficial owner of a company, their FinCEN identifier is no longer being used by any company, or at least that's the case for a person who used their FinCEN identifier for as a beneficial owner. I think that that's true too for somebody who's for a company applicant. But yes, there's a lifetime obligation to update that. There's a number of questions we received about exempt entities. So first of all, if an exempt entity does not need to file a report. If a company filed a report and then became exempt, we received a number of questions about what that entity needs to do now that it's become exempt. And I can take that if nobody else is. So a company that was a reporting company and became exempt after it filed its initial report, it needs to file an updated report, but the updated report is just going to be notifying FinCEN that that company is exempt. On the other hand, a company that dissolves does not need to file an updated report to notify FinCEN that it has dissolved. All right. We received a question about what needs to be reported about a JV partner. If you have a minority interest owner in a company and that minority interest owner is an entity, but it's not an exempt entity.
Yeah, Moshe, let me jump in with that one a little bit. I think you first have to start with recognition that a beneficial owner is an individual. So if you're talking about a joint venture, the question is, what's the nature of the entity first? Is it a reporting company by definition? So for example, we frequently refer to limited liability companies as joint ventures, or that's the structure the joint venture has taken on. And I'm assuming in the question that the joint venture partners, that the joint venture entity itself is a reporting company. You're then looking to see whether or not you have any owners directly or indirectly of 25% or more of the outstanding equity in the company. And you're looking through your joint venture entity to see who the owners, individual owners of that joint venture entity are. And then you're computing their indirect ownership interest in the reporting entity. If there's any individual that has 25% or more direct or indirect ownership interest, then that's who you'd be reporting. In the question, the question is reporting if the minority interest owner is not an exempt entity. So you're going to look through the minority interest owner. I'm assuming in that question it's an entity. You're going to first look at what percentage interest does that minority interest owner have in the joint venture. Let's assume that it's more than a 25% interest. Then you're going to look through that joint venture owner, that minority owner, into its owners. If it had one individual owner, then that individual owner would be the person you were reporting. If it had two individual owners in that minority interest, each of which owned 50%, and the minority interest held by the minority member in the joint venture was less than 50%, then there wouldn't be any individual who owned 25% or more. So there would be nobody reporting. But you'd have to go through those steps to figure out what the individual ownership is ultimately. I'm hoping that's the question that was asked, and that I've answered that. Anybody?
I believe you have.
Okay.
We received a question along a similar line. If you have a company has a managing member, the managing member has control of the company, but only owns 2% of the company. The other 98% of the company is owned by a public company or another exempt entity. Is the exempt entity considered a beneficial owner and what needs to be filed for it. So in this case, like we said, an entity is never a beneficial owner. It's always the individuals who are who own the entity who are going to be the beneficial owner. So if you have a 98% owner, an entity that's 98% owner, let's say we change the facts a little bit. Let's say that entity was not a public company. Let's say that entity was owned by two individuals. Well, each of those individuals own 49% of the reporting company, and they would both be beneficial owners. If the entity is an exempt entity, so instead of reporting the individual, if the entity through which they own their ownership interest is an exempt entity, so instead of reporting the individual's names, because they own their interest through an exempt entity, you would just report the name of the exempt entity as a beneficial owner. In the case of a public company, there may be no individual who through that public company owns 25% or more of the reporting company, and therefore you may not need to report the name of that public company as a beneficial owner. However, you do have to be careful because that public company can have, for example, its CEO or other officers may have rights in the JV agreement, which make them be individuals with substantial control over the JV. And therefore, even though the public company is exempt, because the officers of the public company have substantial control over the JV, those officers may need to be reported.
Yeah, I would point out or supplement what you've said. I think in the question there was a 2% owner, which was the managing member of the JV. So that 2% owner, managing member, you'd ultimately want to look into that entity and determine who's making the decisions in that managing member. If it's the managing member running the entity, then the person making the decisions for the managing member, the person or persons, may well be deemed to be beneficial owners of the underlying joint venture entity. So you have to look at both ownership as well as the function of controlling how the business is run and business decisions are made. You could find in Moshe's answer in the public company that the board of directors of the public company may well be deemed to be beneficial owners because of where they are, except that they're not managing members here. The managing member, it would sound like, is making the decisions to run the business. But you have to look at the underlying documents. What is the role of the players? What control rights do they have? What decisions can they make? That small business financial guide, as I mentioned, is very helpful in laying out examples of what control looks like in these questions. But it's analysis. You have to analyze the documents and the practical day-to-day operating roles.
Yeah. And one last question. Somebody asked about how long it takes to get a FinCEN ID number. So, I know for me it took about 2 minutes. There's information you have to put in your name and the other information that would be required of a beneficial owner. You have to upload an image of your ID. But once you do that, the FinCEN identifier number, at least in my case, was issued right away.
Similar for me as well. I'm technologically challenged, and I was able to do it in about 5 minutes. So it's a very quick process.
Okay. Do we have time for more questions?
Let's take one more.
Okay. There's a lot of questions here. if a reporting company is reporting a beneficial owner by using a FinCEN ID, does the reporting company have to actually know the name and ownership stake of this individual?
Well, the reporting company is reporting its beneficial owners. So it seems to me that the answer to that question, at least at the outset, would be yes. Got to think about that one. But ultimately, if you're looking through other entities, the answer to that may not be yes. I haven't seen that question, so I'm not sure the answer.
Yeah, I think that, right, I think the context of the question is probably where you have a beneficial owner, but they're not directly owning the company. They're just, there's a JV partner, and the JV partner told you, here are the individuals that you should be reporting as a beneficial owner. And, the way I take the question is, okay, do we just report what our JV partner tells us, or do we have to actually do our own diligence to determine who the beneficial owners are? And FinCEN has made it clear that the onus is on the reporting company, that diligence is required. That said, it is something that there's been, clients are struggling with. You have a JV partner. The JV partner doesn't want to tell you all the information. How do you go and get that information? We're working with our clients to do that with their JV partners. FinCEN, in one of the FAQs that they put out, addressed the question, and FinCEN basically said, well, anybody who doesn't, who causes you not to file a report can potentially be liable. So that's really, I think the best that you can do is, notify your JV partner that if they don't provide you the information you need, they can be liable. But, it's one of the reasons why going forward, like Ali mentioned before, we recommend that in all JV agreements, there be provisions requiring the JV partner to provide the information that's necessary to comply with the CTA.
And be responsible for the accuracy of the information provided.
Yep. All right. I think with that, we finished. Thank you, everybody, for joining us. And please reach out with any questions.
Any further questions?